I'll turn over to the panel and start with Leigh Howard. Leigh is a solicitor practicing in workplace relations, employment and safety at Clayton Youths. He is also a pro bono coordinator at his firm, which sees him run a homeless person's legal clinic for Filch. Leigh holds an honors degree in law and a bachelor's in international relations from La Trobe University. Prior to joining Clayton Youth, Leigh was a senior associate to Judge Ginninan, the County Court of Victoria. Leigh's an active user of social media, and you can find him on Twitter. Leigh also is the author of an article that was published in the LIJ in 2012 titled Yours Tweetfully, Social Media Employment and the Privacy Paradox. Leigh will focus today on recent major developments in relation to social media in the employment, law, and unfair dismissal cases. In addition, he'll focus on creating a safe environment on social media for employers in the context of discrimination, harassment, bullying, and victimization. Leigh? Feel free to.
Thank you, Nelson. Can I pass it? There we go. That's my slide. Good. So my purpose today is to talk about social media disasters in the employment law space. Social media impacts upon employment law. It's very interesting and important ways. In fact, I dare say that some of the first jurisprudence to interpret the nature of social media is jurisprudence deriving from employment tribunals. The first and most obvious place to start, as Nelson pointed out, is to explain how social media impacts the unfair dismissal jurisdiction. There are many cases where an employee has done something allegedly repugnant to their contract of employment when using social media, subsequently been dismissed, and then challenge that dismissal at the Fair Work Commission. You've most likely heard of these cases. They're fervently reported by the press. These cases confirm a trite legal maxim that if you have nothing nice to say, don't say it at all. I'm not going to dwell on these cases, but I make the following points. First, these cases confirm that an employee may be disciplined or dismissed if they use social media in a way that injures an employer's interests. Second, it is no defence that employees' privacy settings are being used. Social media users are still viewed as publishers in a public realm. Third, employers are increasingly expected to regulate social media activity through HR policy and training. Now, I sent the LIB a paper for you guys that will discuss these cases more in detail. I originally published in the LIJ, but it's not in a conference pack. So email me if you're interested. I note that in May this year, a full federal court, Dowsett, Tracy and Ross, are due to consider an appeal from the Fair Work Commission about a social media dismissal. This will be the first court, quite an important decision, and rather than a tribunal, to consider the scope of an employer's right to dismiss for social media misconduct in the common law world. Those cases aside, I'm presently more interested in how other fields of regulation impact upon social media and the employment relationship. As an employment lawyer, I read the draft Human Rights and Anti-Discrimination Bill with some interest. You'll be aware that discrimination laws prevent discrimination in the workplace and can make employers vicariously liable for discriminatory conduct engaged by employees. By its very nature, social media increases the opportunity for human interaction and increases the opportunity for discriminatory conduct to occur, naturally. Therefore, potential litigation over discrimination occurring between two work colleagues over a social media platform is an inevitability rather than a possibility. My question is, would an employer be found vicariously liable for such conduct? The proposed vicarious liability provision in the draft anti-discrimination bill reads as follows. It's obviously confusing, and it's a modern draft, but it basically says that if an employee engages in conduct connected with their employment, the employer is taken to also have engaged in that conduct. However, the employer is not taken to have engaged in that conduct, provided they took reasonable precautions and exercised due diligence. In my humble opinion, this section is exceptionally broad. broader than equivalent provisions in current day discrimination law and far beyond how vicarious liability is understood in common law. On my reading, it can deem an employer liable for conduct by an employee so long as the conduct is connected with their employment. There is no frolic of their own to be read into this section. Potentially means that employers who act outside the scope of their authority in complete repugnance to their contract of employment will create the same legal liability for their employer, so long as there is a mere connection to the workplace or their employment. So if you want to apply this to social media, would a connection with employment be established between discriminatory Facebook comments passing from one employee to another? Given that this legislation must be interpreted beneficially, I think the answer is clearly yes. Social media also impacts upon occupational health and safety duties. In the age of trolls and cyberbullying, what these duties precisely require makes for interesting conjecture. Under Victoria's OHS Act, employers must provide and maintain a working environment. I can't click slides for some reason. Are you able to click the slide across? Thanks. So they must be able to provide and maintain a working environment that is safe and without risks to health, so far as reasonably practicable. That is a safe working environment, not a safe workplace. In a world where the concept of a four-walled office is dead, a working environment clearly extends to internet use and could extend to social media. Employers must also monitor conditions at any workplace under the employer's management and control, so far as reasonably practicable. Logically, employers cannot monitor and control the workforce's social media activity at all times, but what employers can easily monitor is social media use that makes mention of them, directly or personally, or where a member of the public writes to them directly through a social media platform. At a minimum, therefore, I think the OHS Act requires employers to monitor situations where social media use is being used on behalf of the employer as a part of employees' duties. So, for example, people maybe in this room, PR and marketing types, they're engaged or employed to represent that company on a social media platform. I think these kinds of workers are vulnerable to being subject to some very poor behaviour on social media, which colloquially is called trolling. This is particularly the case when the employer is a large corporation or a large government entity. It seems to be a favourite pastime of some members of the public to throw mud on these type of entities. While no one intends to shoot the messenger, there is a large risk here that the marketing or PR employees who operate on social media on behalf of their employers will take this vitriol personally. So here is where the employer's OHS duty really comes to the fore, in my opinion. I believe that the OHS duty would require an employer to monitor their social media presence and identify this type of conduct, take steps to eliminate it and minimise it, train their marketing and PR employees how to deal with it, make counselling and related resources available when they are subject to it, and ultimately ensure that those who are entrusted with using social media on behalf of the employer have a thick skin. One final word about policies. HR policies addressing social media conduct is the key way to ensure that reasonable precautions and due diligence or reasonable practical steps are taken to minimise social media disasters. Just last Friday, Justice Buchanan of the Federal Court issued a timely reminder about what types of things employers have to include in a social media policy, their HR policies generally. His Honour was called upon to consider whether a company was vicariously liable for sexual harassment committed by one employee against another. The company had a sexual harassment policy that operated globally across its operations around the world, so it was very, it tried to tick off every jurisdiction. It was very broad. His Honour found the policy inadequate and the employer vicariously liable. His Honour went on to say that the company's policy required advice in clear terms that sexual harassment is against the law, and importantly needed identification of the source of the relevant legal standard. Following His Honour's ruling, and given what I've said this morning about possible reach of these laws, I imagine